If there is a dispute, like I said, between you and your broker, the division just wants you to sue each other. Now let's talk about suing for commissions. The only person that can sue a buyer or a seller would be the principal broker. There's not a direct link between a sales agent and the client or the customer. You have to go through the principal broker. So if you are the principal broker, you could sue directly, but as a sales agent, your broker's the one that has to sue because, after all, they own the listing contracts and they own the buyer's agreements as well. Trust accounts, every broker has to have one. They're personally responsible for all the money in the account. You have to reconcile these things monthly. On the checks and on the account, it must say real estate trust account. These are non-interest-bearing accounts. It has to be kept in the state of Utah. The broker must notify the division of all the accounts they have. They can have as many as they want, but no secret trust accounts. You can only keep $500 of your own money in that account as a broker. If it's more than that, it's going to be called commingling. It's an account for other people's money. Where do we put other people's money? In the trust account. If you take an offer from a buyer and the offer is accepted, that earnest money on that offer must be deposited within 4 business days after acceptance, because that's what it says in the REPC contract. The REPC contract says that the earnest money will be deposited in accordance with state law after acceptance, upon acceptance. The actual state law says it has to be deposited 3 days after receipt or is otherwise agreed to between the parties. Now the test will be very clear. It will say state law or it'll say statute, and that's 3 business days after receipt of the money or is otherwise agreed to between the parties. Or it will say upon acceptance. Well, what's the difference? Well, the difference is if you took an offer from a buyer and you can't present it to the seller for a week or so because they're incommunicado, under the law, you have to put that money in a trust account even though it hasn't been accepted yet. Well, that's why we have the REPC. The REPC fulfills the law when it says or otherwise agreed to between the parties, because the REPC is an agreement between the parties, and that says that you can put the money in the trust account only after acceptance. You could agree on any other date you want to put the money in. That's not a problem either. You can put it a month out, but that would be an agreement between the parties as well. In accordance with the REPC, court order, or written agreement between the parties are the only 3 ways money can come out of that trust account. If you said on an offer, REPC, that you had received $1,000, you dang well better have that in your hand, because that part of the REPC where you're signing for that is actually a receipt. And if you really didn't get that $1,000 or that $1,000 check, then you're really lying to the seller. If you want to, earnest money could be put in an interest-bearing account. That's kind of unusual, but that could happen if it's a large amount of earnest money and considered foolish just to keep it in a non-interest-bearing account. Or it could be put into a special interest-bearing account where the money goes to charity. In either case, it has to be agreed to by all parties. Normally what brokers do is take the $1,000 or $4,000 or whatever it is, earnest money, out of the trust account, put it into a normal operating account, and then they pay commissions out of their operating account.